Welcome everyone, and thank you for joining us on this very warm day and giving up your lunchtime to listen to us. I'd like to extend a very warm welcome from the Bristol Law Society, and thank you for joining us on another one of our webinars in the current webinar series. Just want to let you know that we are recording the webinar, and it will also go on to the Bristol Law Society YouTube channel shortly if you'd like to watch it again. And so today you're going to listen to Guy and I talk about asset protection and tax on divorce. You'll notice that Guy is not actually Tim. Tim unfortunately couldn't join us today, so Guy is very kindly helping me out, and which is great. We are going to, you can post in questions as we go along, but we have set aside some time for that at the end, so feel free to ask any questions that you've got or any queries, and we can look at those at the end of the session. So just in terms of a little bit about us, so I'm Mary Gaskins, and I'm a director at Burges Salmon. I'm a specialist family lawyer, advising a wide range of clients upon all aspects of family law. Have a particular interest in complex financial issues and those relating to trusts and pensions, and also in financial claims on behalf of children. Coming from a farming background, I also have a specific interest in farming cases. I'm on the Bristol Resolution Committee and also sit on the Bristol Law Society Council. Guy is an associate at Burges Salmon in the private client team. He specialises in tax, trust and estate planning. He advises UK and offshore clients, including trustees, entrepreneurs, landed estates and families. His work covers complex succession planning, capital gains tax and inheritance tax issues, and wealth and asset structuring. He's also a member of STEP. So moving on to what we're going to cover today. Sorry, I'm just trying to move on to the next page. There we go. So I'm going to start off talking about cohabitation and unmarried couples, and then move on to asset protection in terms of where the couple is unmarried, but also where they are married. Then moving on to trusts and some commonly held thoughts about those in terms of their role in asset protection. I'll then hand over to Guy, who is going to look at the interplay between wills and divorce, look at some tricky tax points, as well as family businesses and their role with asset protection. We'll then look at a few case studies to put some of the points that we've discussed into practice, and then at the end we can look at any questions that anyone's got. Please do ask some questions if you've got them, and we'd welcome those at the end. So in terms of unmarried couples, just a few kind of facts about those really, and the cohabiting couples are the UK's fastest growing family type, and the number of them has actually doubled over the last 20 years. Unfortunately, the law on cohabitation has not caught up with the times, and it is really not reflective of what people feel should be their rights, and also it leads to misunderstandings in relation to what their rights actually are. This can lead to complex, often lengthy litigation. And I think this is something that I want to emphasise really, is that even if, for example, one party in a couple does not have any rights over a property, for example, that they're living in with their other half, it doesn't necessarily mean they don't think they might have some rights, and then means that they then go on and try to start litigation or court proceedings, which might then cause issues down the line, even if the court then says that actually they don't have any interest. So it's the hassle factor really, and that's what I'm going to look at, is how we can actually deal with asset protection for unmarried couples, and what you might be able to do to potentially avoid future issues and further down the line. So Just to make sure that everyone is awake in this in this heat, I'm going to do a quick little quiz. I've got three myths or facts here. So firstly, I have been living with my unmarried partner for 30 years, so I am a common law wife and have legal protection. Is that is that a myth or a fact? It is a myth. So unfortunately, many people still believe that common law marriage exists. It was actually abolished in 1753, so it actually hasn't been around for a very, very long time. But people do still believe that you do have rights as a cohabiting couple that may be akin to those of a married couple, and that can obviously cause issues and misunderstandings and people just believing they have more rights than they actually do. So in terms of the next question, my name is not on the title deed, but I've been paying bills and for things like holidays for years. Surely I have rights to the property. Is that a myth or a fact? It's a myth. I think we're getting the common ground from the audience. Thank you. So this is also a myth. Just because one person has been paying bills and things like holidays on a regular basis, even if it's for a really long time, if they don't have their name on the title deeds to that property, it doesn't mean that it doesn't give them a right in that property. And I think again that's something that people don't necessarily understand. They think, well, I've been paying for all the bills for years and years. Why do I not have some interest in the property? But you don't, just from making those payments. There are ways that you can try and ascertain an interest in a property even if your name is not on the title deeds, and obviously this is quite complicated and I'm not going to go into it in detail now, but for example, if there's representations made by the person that owns the property that this is joint property, promises made, for example, and reliance on those, then you can obviously go some way to try and ascertain that that person does have an interest. But just by paying bills and for holidays, that doesn't give you an interest. So the third question: we live together with our two children. If we separate, don't I have a right to maintenance and a right to stay in the house with them? Is this a myth or a fact? You're probably getting a common thread that potentially these might all be myths. So this one is also a myth. Again, this isn't correct. Just because you live together and have children, if you're unmarried, you do not have any rights. So I'll be stereotypical here and say that this is the mum. Does the mum have any right to maintenance from dad? She doesn't know. Obviously, under Schedule 1 of the Children Act, then an application can be made for financial provision for the children, but that's for the children. It's not for mum. So again, if you live together, it doesn't give you the rights that you would have if you were married. So moving on to the next slide. So unmarried couples. So looking at what you can do to potentially avoid issues in the future. One of the most common scenarios that I come across is mum and dad want to give a gift to their daughter, for example, and they want her to buy a house with that. Daughter has a boyfriend, they've not been together for that long, but boyfriend is going to move into that house with the daughter when she buys it. So mum and dad and daughter are all really concerned. They want to make sure that boyfriend, who they've not known for very long, doesn't try to ascertain that he has an interest in that property. So what can you do? Well, one of the options, and a really easy, simple option, is a deed of surrender. So a deed of surrender is a really short form document which essentially states that daughter owns the property in her own name and boyfriend, just because he lives there, doesn't have any right in that property. So it's really straightforward. It's half page, 1 page document, and just makes it clear that the boyfriend does not have any rights or interest in that property. Both parties would need to get legal advice, independent legal advice, and essentially that's to ensure that both parties understand it, but also to avoid boyfriend from further down the line saying, well, actually, I didn't really understand that document. I don't know what it meant. So that would obviously be dealt with by having him taking his own legal advice. That's one way of dealing with it, and actually a really easy way to deal with it and not that timely or costly. Another way is a living together agreement. or known as a cohabitation agreement. This is slightly more detailed, although it can include as much or little detail as you want, but it can set out further provisions, for example, how things are going to work day to day in terms of expenses, but also this can incorporate a declaration of trust where the two parties are obviously owning the property in unequal shares, and you want to kind of regulate and set out how that's going to work. So moving to the next slide. So living together agreements. What can they include? Well, who owns what and in what proportions? So if you have a couple who are both contributing to the purchase price, for example, then they may own the property, say 70-30, or you may just have, in the case of the daughter that I was just talking about, she would just own it 100%. And I think one of the most important things that you can include in that document is about what the contributions and what the effect of making contributions might make from the party that's not necessarily on the title deeds. So for example, if the boyfriend in my earlier example was making payments every month to gas and electricity, or just paying all of the bills, it would make it clear that that does not mean that he's going to establish any interest in that property. He's making those payments and that's fine, but that doesn't mean that he's going to get something as a result of that. It can also set out what happens on separation. As all of us family lawyers know, you have many an argument about who's getting the toilet roll holder. So you can set out who gets what assets, for example, if they were jointly owned, or you can provide a list, for example, and also about who remains in the house. For example, if they both own the property, does one party get the option to buy the other person out, or in default of that, does it then just go on the market and the proceeds are divided, and you can set that out as well. You can include triggers, such as to review the arrangements if they have a child, or engagement, although that may mean that you might want a prenup, or sale of the property, and you can also include the provision position in the event of death. So it really just kind of covers all different scenarios, and it's kind of a step up from the deed of surrender in including more information about how things work on a kind of monthly or day-to-day basis, and obviously that's a bit more involved, but that is also another option that we deal with regularly, and it can just be really helpful in setting out and make it really clear what the intentions and how the property is held. So moving on. So moving on to married couples and asset protection, I think it's probably helpful to have a backdrop of why you need that protection in the first place, if a property was in your own name, for example. Well, as I'm sure you all know, the court has very wide powers under the Matrimonial Causes Act, and they can make lots of different orders in relation to assets in the event of a divorce, for example, orders for sale, transfers of properties, etc. They have a really, really wide discretion, and they look at all the factors of the case, and that's often referred to as the Section 25 factors. And the paramount consideration is obviously any minor children, but then they also look at the needs of the parties, length of the marriage, contributions, and they can therefore take a lot of things into account. So in relation to how capital will be divided on divorce, the starting point, following the landmark case of White and White, which is a farming case from 2001, the starting point is an equal division of that capital. So even if all of the assets are in one party's name, then the starting point would be that they look at an equal division. The court will then look at reasons why that equal division should be moved away from, for example, inherited assets or needs. But it's really key to understand that the court can obviously share assets with the other person, even if that in one person's name or came from that person's family. So essentially in doing asset protection, you're trying to prevent an asset from being shared or prevent an asset from being subject to the sharing principle. And moving on to the next slide. So the key case in with marital agreements is obviously Ravmacher and Granatino from 2010, and this was a Supreme Court decision. I'm sure you've all have heard of it millions of times, but it's so important that that's why I'm talking about it here, really, because it really sets out those key points that we need to look at when drafting marital agreements. This case essentially created a presumption that a marital agreement would apply, but you need to follow really important safeguards, and those were set out really clearly in the case. So this is disclosure. So both parties, even the person with lesser assets, has to provide full and frank disclosure. And if one party's assets are really complicated, for example, maybe they hold land in really difficult and just confusing ways, then look at ways to make that clear. You know, provide plans, maps, for example. It's about making it accessible so that disclosure is full and frank, so you can actually understand it. Both parties need to take legal advice, independent legal advice. So one solicitor cannot act for both parties, and quite often the person who's instigating the prenup or postnup, their solicitor can provide names of solicitors for the other person, and that's often really helpful in just making sure that everything runs as smoothly as it can, and just kind of keeps everything kind of quite calm, and tries to kind of reduce the stress that can sometimes be brought into it. And then importantly, the agreement needs to meet needs. It has to meet the person who's more financially vulnerable, has to meet their needs. There's absolutely no point in having a marital agreement which means that one person gets everything and the other person's left with nothing, because a court is very unlikely to uphold that if it's challenged, because it does not meet the needs. And that's what I think a difficult part about marital agreements is, ensuring that you are meeting the needs of the person who usually has the lesser amount of assets, because you're looking to the future. But that's what you need to look at, and you need to look at the different ways that can be done. And both parties need to make sure that they're not under any undue pressure. So you don't have one person later on saying, well, actually, I was forced into signing it, I didn't want to sign it, and that's why I don't think it should be upheld by the court. I think this really ties into the timeframes. The Law Commission report from 2014 was not made into law, but the recommendations are kind of followed as good practice, and their recommendation was that no prenup should be entered into less than 21 days before the date of the marriage. And obviously I think the reasons for this is just kind of day-to-day life, really. You don't need a prenup being tangled up in all your wedding admin, deciding your table plan, for example. You just need to get it out of the way, sort it out, and then you can just put it to one side. This doesn't mean that if you have somebody ring up and say, I want a prenup, I'm getting married in 2 weeks, that you can't do it. You can include different provisions, different wording into the draft agreement, which explains why the agreement was signed closer to the wedding, and just some caveats that obviously that doesn't mean that it's not valid, and you understand that it should be done more than 21 days. So it doesn't mean that you can't do it. It's a good idea if you can think about it in advance to kind of get on and get it done. So moving on. So who should have one? Well, I've kind of touched upon that a bit already. But if you essentially, someone who's got an asset that they want to try and ring fence, or they want to prevent it from being shared, then that would be suitable for looking at a marital agreement. Quite often I have clients who it's dynastical. There's a family estate and they want to try and preserve that for future generations, including their children, and they don't want that to be divided up on divorce. It may be that it's owned with other siblings, for example, and you may just want to ring fence one thing and then leave the rest open to be shared normally. Another really important class, kind of group of people that really ought to consider marital agreements are those moving to this country, for example, from Europe, where they have a separation of property regime already, and sometimes it's not commonly understood that we don't have that here in England and Wales. So actually they may want to do a postnup to reaffirm what they signed up to when they got married, and to make sure that in the event they did get divorced here, which they could do if they had jurisdiction, that actually their separation of property regime was followed, rather than the principles of English law applied instead. So I think that's a really good thing to remember. And then second time arounders, they quite often want a marital agreement because they've been divorced already, or they've been married already, and they want to preserve their assets for their children. They don't necessarily want to share it with the new husband or the new wife. So moving on. So what do they say? Well, they can say whatever you want them to say. They're bespoke agreements. There's not one precedent that fits all. It depends on what's trying to be achieved. And I think what the needs are of the more financially vulnerable party is really key in terms of drafting, because you can be prescriptive, you can provide some specific figures for, say, a lump sum for their housing. You can include formulas in relation to their income needs, to provide a formula for a second lump sum to cover those, or you can just leave it more open and look at needs being assessed at the time of the divorce, to leave it more open that way. But it's really important to kind of look at what those needs might be. And then you can also include how they should be treated on death as well. So again, you can kind of add additional layers into it if you want to. So moving on to what the courts are doing. Well, obviously there's many reported cases involving marital agreements, and I think the key message is that they may not always be upheld to the letter or to the number of what that document says, but there's a number of cases that show that sometimes the spirit of the agreement is being upheld. And the case of nuptial and I think is a good one to show that, is that in that case it wasn't completely upheld, but actually the husband would have got a lot more if that agreement had not been in place. So I think you are always better off having a marital agreement than not having one. And the Radmacher and Valentino obviously applies to postnups as well as prenups, and so you're better having one than you are not. And the onus is also on the party that wants to show why it should not be followed. So if it's there, then it's going to be argued that it should be followed, and sometimes that can be dealt with as a preliminary issue. And moving on, so I'm just going to talk about trusts briefly. And trustees and beneficiaries often think that a trust structure is like the answer in terms of protecting assets in the event of divorce. That's not really the case, and the court does have far-reaching powers to take trust assets into account in the event of divorce. And they can also distribute assets, and they can even rewrite or tear up trust deeds. So I think quite often people think, oh, just pop some assets into a trust and then it'll be fine because no one can touch that on divorce. And we quite often get asked that. And we have to kind of break the news that actually that's not really the case. And actually you'd be better off having a marital agreement to try and ring fence those assets rather than putting them into a trust. There's still the disclosure obligations to provide information about the trust. Trustees can be joined to court proceedings in order to provide information, but trust can be attacked by the court in various ways. The most common way is that it's treated as a resource of one or both parties that can be taken into account. And that's how it quite often gets pulled into divorce proceedings, because it's still there. It may be in a trust, but it's still an asset, and it still needs to be included when looking at what an overall financial settlement should be. Nuptial settlements, if it's classed as nuptial, can also be varied by the courts. And then the third way is that there can be judicious encouragement. So, for example, a court can make an order which requires, say, a lump sum to be paid to the other party who's not a beneficiary of the trust, and maybe that can't be met by assets outside of the trust, but the court is basically encouraging the trustees to make a payment to the beneficiary so he or she can meet that award. So there are a number of ways that trusts can be attacked, and they definitely aren't the answer in asset protection. You might be better off having it in a trust than sat in a bank account, obviously, for various other arguments. But in terms of meaning that you can just forget about it and it doesn't get subject to the sharing principle, it does. And I think that's probably just worth taking into consideration. I'm not going to talk about companies and their role in asset protection, such as the Preston Petrol case, but Guy is later on in his part of the talk going to look at family investment companies and family limited partnerships and kind of their role and the link in with asset protection. And so I think that's over to Guy now to continue.
Thank you, Mary. Good afternoon, all. So as Mary mentioned at the start, I'm going to look first of all at the interaction between wills and divorce. And I think at this point, it's quite good to start off with looking at the question of wills and prenups. So what's the position on the way into the marriage? And then I'll come on to talk about what's the position on the other side. So as you all no doubt know, marriage revokes a will in any case. So anyone who's looking to get married and is putting in place a prenup should also be considering putting in place a new will in contemplation of the marriage in any case. And the question really there is, how generous do they have to be to their new spouse? So if we take the example of someone who perhaps is marrying for the second time with children from their first marriage, and they've quite sensibly put a prenup in place and made sensible provision for their new partner on divorce, well, what can the terms of their new will say? You know, can they decide to bypass the bride or groom to be and leave their estate to the kids from the first marriage when they die? And of course the answer is no. If there is a prenup, then the will should be at least as generous as the prenup in its terms. So if the prenup says the wife to be would get X on divorce, then they should at least get X on death. And why is that important? Well, if a person receives less than reasonable financial provision, then it is possible for them to make a statutory claim under the Inheritance Provision for Family and Dependence Act, 1975, commonly known as the 1975 Act. Now, in the case of spouses, they have a higher entitlement than most other claimants. So most other claimants are only entitled to what is required for their maintenance, broadly, whereas spouses can or should receive what is reasonable for them to receive, regardless of whether those funds are required for maintenance or otherwise. And there are a number of factors that a court would consider when determining the level of the spouse, and one of those is what the spouse might have received in the event of divorce. So if, in the example of this couple, there is a properly drafted prenup in place, the court would really look to the terms of the prenup to see what that provided for and compare that to the will and go from there. So that would be a fairly easily made out 75 Act claim for the wife, the second wife in this case, if the will hadn't been as generous as the prenup. And that's likely to be a costly exercise for all concerned, in particular if the deceased husband has left assets to his children from the first marriage. It's unlikely they'll want to give up their share without a fight. And so the overall takeaway is it's much better to make sure that the will fits in with what the prenup says, and it all matches up on the way in. So if we now look to the next slide and we look at wills in the event of divorce, I thought I'd also go for another quiz. Unfortunately, I don't have the animation available to Mary, but and we can't take a straw poll, so it's a fairly sort of one-sided quiz, but there we go. But anyway, so we're just going to have a look at see what is revoked in the event of divorce and when it's revoked. So is a will revoked on divorce? Well, the answer is no. It's not revoked on divorce, so the decree absolute itself. It is revoked on marriage, but not when that marriage is resolved. So broadly, the document continues to take effect after the divorce. But if we look at question number 2, what about the executorship? So who's appointed under as executors under the terms of the will? Well, if we look at the appointment of a spouse as an executor, well then, yes, that is revoked on the decree absolute. So if a person dies without making a new will after the divorce and they've only appointed their former spouse as an executor, that no longer applies. And so you'd be looking in that case for someone, most likely beneficiary, to apply for letters of administration on the death. Number 3, gifts. So gifts under the terms of the will. So again, in respect of any gifts to the spouses, yes, they are revoked on the divorce. Well, they're treated as though the spouse has died. So again, it's important to revisit the terms of the will at that point to work out what the default provisions would be if, you know, the estate's just left to the spouse, you know, who, if he's considered to have died at that point on divorce, then on the decree absolute, sorry, then where does the estate go? At the very least, you might have some unexpected beneficiaries, or at the worst, if the will hasn't catered for that eventuality, you might be looking at an intestacy. And then finally, in our little quiz here, we've got guardianship. So broadly, divorce doesn't have any effect on guardians, as the parental responsibility doesn't change as a result of the divorce. So a person with parental responsibility can appoint guardians for their children. I think the practical point is that it's important to bear in mind that the appointments from both on separating parents should ideally match in their wills, in their new wills, hopefully, because each appointment will be valid and broadly should only really be drafted to come into effect on the death of the second parent. So if the appointments don't match, you could have a number of different people being appointed, and that could be complicated, or at the least, and at the worst, could be quite acrimonious. So in the context of divorce, it all argues for getting a new will in place as soon as possible, really. Of course, in terms of what should be included in that new will, you'd have to regard to any ongoing maintenance provisions that need to be honoured, and be conscious that after the divorce, the testator or testatrix will have lost the spouse exemption. So any tax planning, or indeed an existing will, might need to be revisited. And of course, if they remarry again, then they'll need a new will at that point. It's important to note finally that with respect to wills and divorce, that until the decree, the will would take effect as if there are no proceedings. So separation in and of itself doesn't affect how the will would operate. So if you die in that interim period, then the person you're in the process of divorcing could inherit anyway. So that might argue in favour of a holding will, really to cover the interim period that can then be finalised or reviewed once the whole process is sort of done and dusted. And indeed, I've got similar current matter with one of Mary's colleagues at the moment, where the lady in question has put in place a holding will by which she just, if anything did happen to her in this interim period, her estate would go to her nephew and her niece rather than her soon-to-be former spouse. So that's wills on divorce. It's also probably worth quickly touching on family trusts. Not relevant to everyone, but if it is the case that there are certain family trusts in place and the spouses are the trustees, for example, then it's important to note that the appointment of the trustees would continue post the divorce. There's no automatic removal of a trustee in the event of the divorce. And it can be hard to get rid of a slightly belligerent trustee if they don't want to retire. So this would need to be given careful consideration, and it might be that their retirement of the particular spouse as trustee would be made a condition of whatever settlement is agreed between the parties, or perhaps included in the terms of a court order. If, for whatever reason, the husband and the wife think that they would like to continue to remain trustees together, it's important to note that trustees must act unanimously. So query whether the husband and wife, or soon to be the former husband and former wife, could act together going forward, or whether there just be perpetual deadlock when it comes to trustee decisions. Finally, in terms of the trust, it's important just to look at the class of beneficiaries to see what is the entitlement or the rights of the ex-spouse, whether they is there any possibility of them benefiting, and if there is, to check whether that spouse or ex-spouse can be excluded as a beneficiary, or the trustees could exercise a power of appointment to narrow the class of beneficiaries. And then finally, lots of clients will have sort of not active trusts but in place, but things like life insurance policies, death benefits, pension trusts. It's important just to review that to see whether spouses have been appointed as trustees of any of those types of trust arrangements, or indeed nominated as beneficiaries, and get that tidied up as part of the whole process. So that is the interaction of wills and divorce. And then I'm going to talk now to the tax points, of which the main one is capital gains tax. And really that stems from the fact that in terms of the provision on divorce, there'll often be the transfer of capital assets between the divorcing spouses, which can in some circumstances lead to CGT. That said, income tax might be an issue for some married couples after the separation if they have particular assets that can be taxed as income rather than capital, such as insurance bonds. But what I'm going to speak about now is really aimed at CGT, and it's aimed at married couples and civil partners. Cohabiting couples don't really have any of the benefits I'm about to discuss, so they would need to be considered separately, and that's probably a talk for another time. So, as with most taxes, timing is key, and in respect of capital gains tax on divorce, you have to really look at the time, the transfer of the asset from one spouse to the other when it takes place. So the broad rule is that transfers between spouses are broadly not subject to CGT, that they're on a no loss, no gain basis. And that treatment will continue for the spouses during the tax year of separation. So it's important to note it's not a year from the point they separate, it's until the end of the tax year in which the couples separate. So all well and good, but what does separation mean? Well, obviously, it's, as with all things, it's a question of fact and degree. And really, you're looking for the point at which separation becomes permanent. And I appreciate that can be hard to say sometimes, and some couples might have a trial separation which later becomes permanent. But for example, issuing proceedings might be a good indication of separation, but not necessarily. And in some circumstances, HMRC can and do argue that it's as to the exact point of separation when that occurred because of this particular tax treatment. So CGT, no loss, no gain in the year of separation. And that means broadly that the spouse who's receiving the asset receives the asset, and the base cost for their CGT tax purposes is the historic base cost. So if they then sell the asset in future, the starting point really is the base cost for which the sort of transferring spouse bought the asset or inherited and received the asset previously. So that's in the year of separation. What happens? So if you take, let's take an example. We've got a couple who they've separated this year in the tax year 2020, 2021. So up to 5th of April 2021, assets between them will be treated on no gain, no loss basis. From 6th of April 2021, that doesn't apply. So what's the position there? Well, if at that point there's been no decree absolute and the couple are still married, then they are considered connected persons for CGT purposes. And for as long as they are connected persons, transfers between them of assets between them are deemed to take place at market value, unless they're a bargain at arm's length terms. So that means that transferring assets from one spouse to the other is deemed to take, the transfer is deemed to take place at value as of the date of the transfer, and tax is calculated, CGT calculated accordingly for the spouse who's transferring the asset. So transfers after the tax year of separation can, but before the decree, can lead to unexpected CGT. After the decree absolute, then the spouses cease to be connected persons for CGT purposes. So broadly, that means if there's a sale of an asset from one spouse to the other at that point, then you don't use the market value rule, and it's the normal computation rules apply. So it's the sale of the asset, the value of the asset subject to the sale, provided it's a bargain at arm's length terms. If the asset's transferred pursuant to a court order, then you need to just be careful that section 17 Taxation of Chargeable Gains Act 1992 applies, and that still deems the value to be market value as at the time of transfer, which may or may not be more than sort of the sum that would be paid on a sale, but you could end up with a slightly higher tax charge. So you just have to be aware that if the transfer is made after the court order, so after the decree absolute pursuant to a court order, then you have to consider the application of Section 17. So finally, in terms of timing, what's the date that's the key tax point for the date for the transfers? What's the date of the transfer? So if there are no court orders and it's by contract, the transfer is by contract, then you're looking at the date of completion, or if it's a conditional contract, then the date the condition is satisfied. If it's a transfer by court order, then broadly the date of the consent order. And if the order comes before the decree absolute and the transfer is made after, then it's the date of the decree absolute. I'm quickly going to touch on the family home because I understand that is likely to be the most significant asset for a number of, for many couples. I'm not going to cover possible trust arrangements today, but more the sort of pitfalls of straightforward transfers between the couple. So if we go back to our starting point, transfers of an interest in the family home from one spouse to the other in the tax year of separation, no real issue for CGT purposes because there'll be no gain, no loss. Thereafter, you need to start thinking about CGT, and you might think, well, that's okay because this is the main residence for these two individuals, so it should apply. To me, there's no gain, chargeable gain, but the problem with divorcing couples from CGT perspective is that often they'll usually stop living together. And so one of the couple will move out, cease to occupy the family home as their main residence, move somewhere else. And then it's most likely the one who's left will be transferring their interest in the property to the one who stayed. And in those circumstances, they may not qualify for main residence relief if the transfer is after the tax year of separation. It's not completely lost because they'll still have the 9-month window, which they can beyond which past the point of them leaving the property, and up to the sale of the asset, they get they can apply for exemption for the final 9 months of ownership. So provided the person moves out and at that point, after 9 months, the property is sold, then there should be no CGT, should still be able to claim the main residence relief. Outside of the 9-month period, say, for example, if a husband moves out after 3 years of living in the house as his main residence, and then 3 years later the house is transferred by court order, which is deemed to happen at market value, and then broadly you've still got PPR, that's main residence relief, for the husband for the first 3 years, plus you get your 9-month final period exemption, and then so you'd then be looking at CGT for that interim 27-month period. So that you'd have to calculate those gains in that scenario. There is a possibility to apply to the court for an extension of the relief, but I don't propose to go into that in too much detail today in view of the time. I have got a quick example of where the fortunate position where couples might have two properties that they both own jointly, and what can happen in the circumstances where they swap houses, basically as part of the divorce settlement. So here we're looking at Mr. and Mrs. Carter, and they own two properties, Blue Rock and Reasonable House. They both own both properties jointly. Blue Rock is the family home, which I'd say let's go for the bottom right-hand property, looks very nice. And Reasonable House is born as an investment property and is let out on the left-hand side there. So things don't go particularly well, and Reasonable House on the left there becomes vacant, and Mr. Carter moves in, leaving Mrs. Carter in Blue Rock. And then after 3 years, they decide to divorce, and as part of the settlement, they decide that Mrs. Carter should get Blue Rock and Mr. Carter should keep Reasonable House, because they're both about the same size and worth about the same amount. So that involves Mr. Carter giving his interest in Blue Rock to Mrs. Carter, and she will give her interest in Reasonable House to Mr. Carter in return. So from the CGT perspective, they're outside the tax year of separation, and they're outside well, we can talk about the 9-month window, but and if they make the transfers after the decree absolute under the court order, they're not connected anymore, but market value is imputed on the basis that there's no bargain at arm's length terms, because it's under the court order. So you think, well, this doesn't look great, because potentially looking at CGT for both of them, and possibly worse for Mrs. Carter, she will get no principal private residence main residence relief on Reasonable House, because she's never occupied the property as her main residence. However, section 248 subsection section 248E of the Taxation of Chargeable Gains Act can come to their aid and mitigate the CGT charge. And broadly, where that applies, where joint owners of 2 or more properties split up the properties so that they both swap their interests and they walk away with, they become the sole owner of one of the properties, and provided that they each qualify for PPI in relation to the house that they end up receiving, then so i.e. they occupy the house that they receive as their main residence, then they should be able to benefit from the relief, because what they're considered to give up, i.e. the value of the property they give up, is treated as such as there's no gain, no loss. So again, use the historic base cost, but there's no immediate charge to CGT on that transfer. There is similar partition relief for land that is not residences, such as a plot of land, which is under section 248E, but TCGA, but I don't propose to go into that today in view of the time as well. Sorry, Mary, thank you. So that's a little bit more detail on the question of house swaps, but we can move on from that. Finally, if we're talking about transfer of business assets, then again, look at when the transfer happens. If it's outside the year of tax year of separation, then you'd need to look at all of the normal reliefs that apply for business transfers. So mainly holdover relief on gifts of business assets, essentially, or entrepreneurs relief if there's going to be a sale. In respect of holdover relief, legislation doesn't refer to gifts, but to disposals otherwise than under a bargain at arm's length terms. But broadly, what you need to know is a court order fits that description. So holdover relief can apply to a transfer of business assets under a court order, provided the other conditions are met. And it's important for both the spouses to sign the election, so that should also be made a condition of the transfer. Finally, on the tax side, there's a little slide we've got coming up, Mary, on IHT. Not generally a big problem, so inheritance tax on divorce, because in respect of transfers, until the decree absolute, the spouse exemption applies. And thereafter, maintenance payments would likely to be gifts out of excess income from one spouse to the other, rather than potentially exempt transfers. If there are any larger sums, then you might look to Section 10 of the Inheritance Tax Act 1984, which to show there's no intention to confer a gratuitous benefit, and therefore should be no transfer of value, or Section 11, which applies for payments made for the maintenance of the family. If there's a trust that's ordered by the court as part of the arrangement, then that trust would normally fall under the relevant property regime. You might get Section 10 or Section 11 to apply to relieve the entry charge going in, but exit charges or tenure charges might otherwise apply. And if for whatever reason there are larger payments going to children, it's unlikely that Section 10 or 11 would apply, and they might confer a benefit rather than being simply for maintenance, and they're likely to be pets. And finally, there's an exemption there. As with all transfers of assets, particularly land, interest in land, you need to consider the SDLT position, but there is a general exemption for transfers made under a court order or in contemplation of a dissolution of a marriage. So that's something to be aware of. Now, finally, there's a slide. The next slide talks about a little bit about family companies and asset protection possibilities here, and then we can move on quickly to the case studies we've got for you. So I think it's important to distinguish between family businesses, trading businesses that might be owned, by a family through many generations, and family investment companies, by which I mean investment vehicles set up by mum and dad, perhaps owned by mum and dad and the kids, which are used primarily for inheritance tax planning or as sort of investment vehicles where they can roll up in a lower tax environment. I think in both cases, the asset protection piece is really to try and protect and preserve value and family wealth within those entities and not be subject to challenge from unruly spouses on the way out. Of course, with the family business, there's also the question of you want to limit disruption to the trading operation or the management of the business to the extent that one of the family shareholders is going through a divorce. So that's always something to bear in mind. In terms of the asset protection and restrictions on shareholders, so family shareholders, sons, daughters, being able to transfer shares to spouses, normally we would try to include restrictions on transfers in the Articles of Association, defining a class of permitted transferees, generally family members, and making sure that shareholders can't, or directors don't register any transfers to other non-family members, which provides an element of control. Some families prefer those to be in a shareholders agreement rather than in the articles, because otherwise they are publicly available document. But really broadly, the idea is that there's director control of share transfers to mean that the shareholdings remain within the family. There's also the possibility of saying that in the event of the divorce of a family shareholder, then the company will buy back those shares for zero value. And we'll come on to that in one of the case studies very shortly. But there are potential IHT consequences to that. As a result, whether it's a family business or a family investment company, and there's significant value at stake, you often find mum and dad ask family members to sign prenups with their future spouses. And where you have a multi-generational type family business, it's often the case that they want to put in place a formal constitution to really note down how the ownership of the company is to be managed going forward, remain within the family, and make sure that the management in no way extends to spouses in any way in the future. So a quick bit through that, and in the knowledge that you all probably, no doubt, rather hot, and we're coming towards the end of our time now, but we do have 4 quick case studies to go through, and I'll let Mary talk you through A to C at least.
Thanks, Guy. Yeah, so as Guy said, I'm conscious that everyone's probably melting, so we'll run through these as quickly as we can. Just in terms of case study A, I think the point behind this one is just to kind of look at balancing the need for kind of tax kind of savings and being tax efficient versus moving property into your spouse's name. So for example, moving investments over into their name, or for example, if you've got a business, transferring shares to qualify for tax relief. So I think it's just looking at weighing those options up, and when you're doing that, take some advice and think about whether or not it's something that you do want to do, and think about the necessary implications that might happen in the event of getting divorced. So moving on to case study B, this is a case I had a while ago, and it just kind of shows a slightly different angle of how you can use kind of asset protection to sometimes stop something from completely falling apart. The case was a farmer, and he had children from his first marriage, and then there was another child with his second wife. There was pressure to give the assets to the oldest children, but then what would be left for the second family? And the wife was very kind of stressed and upset about what she would get. Would she be left with anything? And she felt like the only way to have certainty would be to get divorced, because then she'd know what she had. This seemed quite an extreme kind of way out, on the basis that neither of them really wanted to get divorced. So one of the things that we put forward was a postnuptial agreement, and actually set out what she would get, and actually affected those transfers of land, to give effect to that to a certain extent, to give her her certainty and some security, and that actually avoided them getting divorced. Post-ups can therefore be a really useful tool, and as many people say, nothing says I'm sorry after you've done something wrong like a post-nup does. So I think it's just looking at that from a slightly different angle, and sometimes you can actually use them and actually kind of in a slightly different way and actually have some quite positive outcomes. So then moving on to the next slide. Case study C. So this is just essentially where the father wants to pass on the family business to the son, but he knows the son's getting married, so he's quite reluctant to pass it on because he's concerned about potential issues if they did get divorced. And also the plan was that the daughter-in-law would work in the business. So the situation here is that we set up a prenup, which obviously set out what was going to happen, and also kind of set out that the daughter-in-law was going to work into the business, but that would not necessarily mean that her share under the prenup would increase. And this therefore allowed that business to be transferred to the son, enabled the daughter-in-law to work there, and obviously gave her an incentive as well by the provision that she was going to receive under the prenup. It just enabled that situation to continue and happen, but putting some kind of formality on it, so it wasn't kind of just transferring it over to the son and keeping it open to be shared completely in the event of divorce. So then moving on to the final case study, and after this then we'll just do some quick questions and you can escape, is just about that I'll hand over to Guy for this one.
Yeah, so we're just going to look here at a family investment company. So take a very hopefully straightforward example. Mum and dad have incorporated a company really as an investment vehicle. They might have contributed £1 million, say, so there's £1 million in the company to invest however they like. They have A shares, which entitle them to voting rights and can control the company through that way. And they have B shares, which really hold the economic rights, i.e. rights to dividends and capital going forward. And then they've gifted those B shares to their children, so that the economic value of the company going forward should be with, it's a pet for inheritance tax purposes, but hopefully they survive 7 years from the date of that gift. And then going forward, the growth in the value of the B shares is in the children's estates and not in the parents' estates. So in that situation, the B shares could be quite valuable for each of the children, but what you'd want to do, as I mentioned previously, is try and restrict the ability of a child to transfer their shares to their spouse. Now, the way that you do that would be to restrict the ability of a shareholder to transfer the shares in the articles, having a class of permitted transferees who broadly are acceptable to mum and dad, who would also be the directors of the company. And that provides some protection, during the course of the marriage. In some circumstances, there might also be a provision in the articles to say that the company will buy back the shares at zero value in the event of the divorce, which broadly would mean that there should be no value to take into account on the divorce, because the shares in that sense would be of minimal nominal value because they'd be bought back by the company for nothing. But the slight difficulty here is that often the aim for a family investment company is to transfer value from parents to children going forward using the B shares. And if there's such a provision in the articles that say this happens in the event of the divorce, well, query whether the value has actually transferred to the children in that case. And so is it really doing the IHT succession planning that mum and dad wanted it to? I mean, it could be that the articles say that in the event of divorce, the shares will be sold or bought back by the company at a fixed price with a particular value. In that sense, there could be slightly more certainty from the company perspective to know that the shares aren't going to go to the spouse, but also the value is limited for the purposes of the financial disclosure. But of course, the main consideration for the family investment company is that you don't, and there's no reason why you would, but you wouldn't issue shares necessarily to the spouse to hold in her or his or her own name. They wouldn't be involved in the management of the company in any way. And importantly, it's most likely that, as I've said before, you had the restrictions in the company documentation or shareholders agreement, but also you combine that with a pre or post nup to make sure the position was as certain as could be. And that's it from me, Mary.
Didn't want to interrupt you, Guy.
No, I'm done. Don't worry.
That's us finished. So thank you everyone for holding on in there.